right, so good afternoon. I have the pleasure to welcome you to the second seminar of our series on legal philosophy between state and transnationalism. When I say we, it's the Nathanson Centre on Transnational Human Rights, Crime and Security, as well as both Osgoode and the Department of Philosophy of York University collaborating to put together these seminars. So today we have the pleasure of welcoming here at Osgoode and York Professor Colleen Murphy. Professor Murphy is an associate professor of philosophy at Texas A&M University. If I may ask, what does the A&M stand for?
Agriculture and mechanical, for mechanical engineering.
Right, but you're at the right talk. This is a philosophy talk. Professor Murphy holds a BA from Notre Dame University as well as a master and PhD in philosophy from the University of North Carolina at Chapel Hill. She specializes in political philosophy, philosophy of law, as well as the ethics of risk and engineering ethics. Interesting combination. Her publications include the philosophical bestseller, so if you haven't gotten it, go to the stores, it is available, A Moral Theory of Political Reconciliation, which is published by Cambridge University Press and appeared in 2010. And she has also authored, obviously, numerous articles in leading journals and edited collections. And today she will speak to us about justice in transitional contexts. As a respondent today, we have our very own Professor Alice MacLachlan from the York Philosophy Department. Professor MacLachlan completed her PhD in philosophy at the Department of Philosophy of Boston University after studying at both Queen's University here in Kingston, as well as the University of Cambridge. Professor MacLachlan works in ethical theory, focusing especially on feminist ethics, virtue ethics, and the role of moral emotions, and in social and political philosophy more generally. Her current research topics include forgiveness, reconciliation, reparation, and apology, as well as the philosophy of Hannah Arendt. She also has interests in the politics of sexuality, and she has published in many leading journals. And if I'm correct, she has a forthcoming edited collection, and I'm correct because I'm contributing to it, as well as a book, I think, that is forthcoming. So without further ado, I'd invite Professor Murphy to make a presentation, present her paper. The papers are always available online before the seminars, but we tend to prefer to have a little presentation of about 30 minutes of the paper, which will be followed by a commentary by Professor MacLachlan of about 10 minutes, and then a short possibility for Professor Murphy to reply, and then we'll open the questions to the floor, and we should be able to wrap up by 4:20, 4:30. So, great. Professor Murphy.
So first, thank you very much for having me here. I'm looking forward to the discussion. This is a paper that marks the beginning of a new project, so like all new things, needs lots of modification and development and revision, which I'm hoping your comments will help me with, and I'm sure they will. So over the past 4 decades, a large number of societies around the world have attempted to transition from an extended period of civil conflict and/or repressive rule to democracy. Afghanistan, Cambodia, Chile, Guatemala, Iraq, Northern Ireland, Poland, Rwanda, and South Africa are just some of the more prominent examples. These transitions have occurred with varying degrees of success, and one condition that's widely taken to affect the success of a transition is a way that a society addresses the characteristic legacy of wrongdoing from the period of conflict and repression. The scale and nature of wrongdoing during the pre-transition period is often truly horrific, characterized by widespread, systematic, and often brutal human rights abuses. Very often a number of unknowns surround such wrongdoing, including the exact number of victims, the location of the remains of victims, the identities of perpetrators, and the exact role of the state in sanctioning or carrying out abuses. Scholars have coined the term transitional justice to refer to the justice involved in transitioning from conflict or authoritarianism to democracy, and in particular in responding to wrongdoing in this context. Questions asked about such contexts include: to what extent and in what way should the past be confronted? Should perpetrators be punished? Should a policy of illustration be adopted? Or should communities concentrate exclusively on the future? Transitional justice now constitutes a growing interdisciplinary academic field. Examinations of transitional justice are often case-specific and empirical in nature. So one primary concern in this emerging field is evaluating the effectiveness of different kinds of legal responses to wrongdoing in promoting reconciliation or ending impunity, and the factors, for example, the way a transition was brought about, that influence which kind of response a particular society selects. In contrast to these empirical studies, my concern here is conceptual and normative in nature. There is wide consensus in the literature on transitional justice that justice demands that a legacy of wrongdoing be dealt with in a way that is both effective in consolidating the process of democracy and at the same time morally justifiable. It's very difficult to satisfy both of these demands in practice. In the existing literature, attempts to grapple with the tensions involved in satisfying both dimensions of transitional justice often rest on a central assumption, namely the assumption that transitional justice is a unique or distinctive kind of justice. That is, transitional justice is presumed to be distinct in some way from the ordinary kinds of justice found in stable democracies. And it's this presupposition that I want to examine in this paper. My primary objective is to identify grounds for thinking that transitional justice is distinctive. Given that transitional justice concerns the morality of responding to past wrongdoing in transitional contexts, there's two obvious possibilities for the source of transitional justice's claim to a unique status. First, the distinctiveness of transitional justice could be found in the distinctiveness of transitions themselves. Second, the source of the distinctiveness could be in the legacy of wrongdoing that we find in transitions. And here I'm going to explore the first possibility, that there's something distinctive about transitions which helps to explain why transitional justice is distinctive. And I consider this possibility because it's the one implicit in most accounts of transitional justice in the literature. Theorizing about justice generally presupposes the existence of a reasonably decent, stable democracy. This is the context for thinking about what I'm going to be calling ordinary justice in the literature on transitional justice. To establish that transitional justice is distinctive, that is, fundamentally different from and irreducible to ordinary justice, theorists try to demonstrate that there's some aspect or characteristic that distinguishes transitional contexts from ordinary contexts. And in the first section of this paper, I'm going to identify three different explanations of what makes transitions distinctive. In the second section, I'm going to consider skeptical arguments advanced against each of these explanations, designed to show that whatever is pointed to as distinctive about transitions can also be found in stable democracies as well. And then in the third and final section, I'm going to offer a novel explanation of the distinctiveness of transitions, one that incorporates what I take to be a central and important insight that the skeptics have, but I hope avoids falling prey to their objections. My central thesis is that two distinct kinds of uncertainty, existential uncertainty and uncertainty about authority, are paradigmatically present in transitional contexts, but rarer to find in stable, consolidated democracies. As such, the presence of these uncertainties as a fundamental and persistent feature of people's lives serves to decisively distinguish transitional from non-transitional contexts. This account won't by itself provide a complete account of transitional justice. So here I'm going to be silent about the substance of what justice demands in terms of how communities respond to a legacy of wrongdoing. However, in the conclusion, I'm going to talk about the theoretical resources I think that my account provides when we start to think about the substance of what justice then demands. So before turning to the first section, just a note about what I mean by transitions and transitional contexts. There's a general consensus that a society is in transition during the period in which political orders are in flux. A transition begins, quoting Rudy Teitel, quote, right after revolution, from an illiberal order, or with a cessation of conflict. While there's consensus that the transition ends when a country has completed the process of democratization, and so we can talk about a full or consolidated democracy, there's substantial disagreement about what marks this point of transition. In my view, some of the criteria for full or consolidated democracy should be derived from a conception of the kind of relationships in which citizens and officials in a democracy stand. The core value that such relationships should express are reciprocity and respect for moral agency, which I argue are expressed when relationships are premised on respect for the rule of law and certain relational capabilities are in place. That's the substance of what I argue in the book on political reconciliation that Francois mentioned. One final note, of course, the determination of whether a particular community is in transition is not always straightforward. And there'll be disagreement often in particular cases about when an old order ended and when a new order began. However, despite disagreement and ambiguity about how to categorize certain moments in a given society, there will be specific moments in which it was clear a society was in flux. And similarly, I take it there'll be certain moments clear when it was that a society was no longer in flux and that an old regime had ended. So turning to the first section, the distinctiveness of transitional contexts. Most theorists interested in questions of transitional justice simply assume that transitional contexts are different from ordinary ones. Few have attempted to offer a sustained argument for or analysis of what exactly that difference amounts to. Rudy Teitl's work is seminal and most influential in this regard, and as such is going to form the focus of my discussion for the first section. Here I'm going to distinguish three different explanations of what makes transitional context distinctive. Teitel herself doesn't distinguish these explanations, and no one in the literature has formulated them as such, so I'm reconstructing them based on discussions by Teitel and of Teitel. So the first possible explanation is that transitions are distinctive in virtue of the distinctive characteristic of transitional contexts. What does that mean? According to the first kind of explanation, transitions are distinctive because there are characteristics of transitional contexts not found in ordinary ones. And one feature highlighted in particular is the normative shift in the conception of justice ordering a community that coincides with a change in political orders. The conception of justice ordering a political community refers to, quote, the principles underlying and legitimizing the exercise of state power, unquote. So during the transitional period, this period of normative shift, standards for the legitimate exercise of power by the state are in flux, with past standards not yet completely repudiated and new standards not yet fully consolidated. By contrast, in the ordinary context of a stable, consolidated democracy, there is a stable conception of justice that legitimates and underlies the exercise of state power. So that's the first explanation. The second possible explanation is that transitions are distinctive in virtue of the distinctive moral questions and dilemmas that are inherent to transitional periods. So a primary source of these questions and dilemmas, it's argued, is the paradoxical role of law in transitions. So in stable democratic contexts, the argument goes, the rule of law is understood to constrain arbitrary government action, in part by requiring stability in the rules governing conduct and requiring adherence on the part of governments to such known rules. However, in transitional contexts, law must provide order and stability at the same time that it facilitates wholesale transformation. One way to see the way in which this changes the questions and dilemmas that arise is by considering the dilemma surrounding the issue of criminal justice, which stems from the fact that a key principle of the rule of law prohibits retroactive punishment. In transitional contexts, the actions that are widely taken to be the appropriate subject of punishment are often arguably legal, though clearly immoral, at the time that they were committed. Thus, transitional punishment seems to involve the application of new norms, which the process of punishment itself is helping to construct retroactively. A prior regime is held accountable according to the standards of the successor regime. The violation of the tenet of the rule of law that prohibits retroactivity in transitional punishment seems troubling, it's argued, not only for its own sake, but also because it calls into question the ability of transitional punishment to be successful in achieving its justifying goal. Punishment in transitional contexts is typically justified because of the role that it can play in the process of democratization. However, to contribute to democratization, the argument suggests, trials must presumably be conducted in a way that adheres to standards of legality found in liberal democracies. By contrast, actions that are legally sanctioned or prohibited are appropriately the subject of punishment, and the standard that regulated actions at the time a crime was allegedly committed are the same standards used to condemn actions in stable democracies. The third possible explanation is that transitions are distinctive in virtue of the distinctive concepts and standards for answering moral dilemmas and questions that we find in transitions. That is, according to this argument, it's a mistake to apply ordinary moral intuitions or standards, and indeed our ordinary understanding of certain concepts to actions in the context of transitions. So Title argues that the standards for justice in responding to wrongdoing must be defined relative to a transition. Justice in transitions, in her view, is ultimately instrumental. A just response to wrongdoing is one that will promote the transformation of a community into a liberal democratic order. Transitional justice is also, Title suggests, ultimately pragmatic. Justice requires, that is, a pragmatic resolution to the dilemmas involved in responding to wrongdoing in transitions. And to quote her, the idea of justice always is a compromise, unquote. By contrast, in ordinary stable democracies, the standards for justice are taken to represent principled, not pragmatic considerations. And furthermore, the demands of justice are characteristically taken to be non-instrumental, but rather deontological in nature. So I've looked at three different accounts of what makes transitional contexts distinctive and different from ordinary contexts. And I'm now going to turn briefly in the second section to look at the skeptical challenges that have been suggested challenging each of these different explanations. And the arguments that the skeptics make are designed to show that whatever is alleged to be distinctive about transitions can also be found in the context of stable democracies. I'll be drawing on arguments advanced by David Deisenhouse, Eric Posner, and Adrian Vermeulen. So in the first explanation I cited, there was an idea that there's a normative shift in transitional contexts, and we don't find normative shifts occurring in stable democracies. However, critics point out, normative shifts do occur within political orders. Such shifts also occur in stable consolidated democracies. So consider the United States. Intra-political order normative shifts occurred following the recognition of new constitutional rights by the Supreme Court, and important policy shifts such as the Civil Rights Act. In each case, there was a significant change in the conception of justice ordering and enforced by the state. Thus, attempts, skeptics argue, to base the distinctiveness of transitions on the normative shift fail. The second explanation pointed to distinctive moral dilemmas and questions that we find in transitions. But critics argue dilemmas and questions supposedly inherent or distinctive to transitions also arise in stable democracies. This is because all normative shifts, in part, give rise to the same kinds of questions. So think about retroactive punishment. One way of framing the general issue that such punishment raises is in terms of the permissibility of sanctioning or censuring past conduct, either by officials or citizens, on the basis of a different conception of justice than that which defined the contours of permissible conduct at the time the actions were committed. But this issue can arise in stable democracies when norms undergo significant change. Politicians can lose elections because of statements they made in the past, which were sanctioned at the time and reflected the norms of the period. In effect, the skeptics suggest, politicians are being sanctioned retroactively in such cases. Judicial nominees may not be appointed because of legal decisions or commentaries on legal decisions advanced in a previous era. And Justice Rehnquist and what he had to renounce, memos he had to renounce, was one example that was cited by the skeptics. The third kind of explanation appealed to the distinctive standards or concepts that should be used to address moral dilemmas and transitions. Skeptics argue, however, it's a mistake to think that we need anything new in order to resolve the dilemmas and questions that arise in transitions. So, for example, consider the question of whether it was morally justified for the South African Truth and Reconciliation Commission to grant amnesty to perpetrators of gross human rights abuses. David Deisenhouse has argued that the best justification that can be offered for the granting of amnesty is in terms of the role that the TRC played in promoting the justice of the rule of law. The TRC demonstrated the consequences of violating the rule of law, which systematically occurred during apartheid, insofar as equal recognition of all responsible agents was grossly distorted. The TRC, he claims, also demonstrated the sense of justice among South Africans was corrupted, insofar as justice was taken to refer to any measure that would serve the ideology of apartheid. And through its contributions, the TRC aided the transformation of South African society. So advocates of transitional justice try to devise distinctive standards of justification, skeptics claim, partly because they set the bar for what counts as a satisfactory justification in transitions too high. Typically, authors assume that in ordinary context, the demands of justice are fully satisfied in practice. However, stable, consolidated democracies, in fact, use a range of tools to respond to normative shifts that are taken to be justified on moral and pragmatic grounds, despite failing to fully satisfy what the demands of justice require in the abstract. For example, governments rarely offer full restitution following periods in which property is confiscated. And the example of Japanese Americans interned during World War II is one example that's cited in this context. And there, the amount of reparations that were given were considered justified, given a balance between concern for protecting a stable system of property rights, which attempts to return all property that was confiscated after significant passage of time would have destabilized, as well as a concern for corrective justice. I think there's an important insight in the skeptical arguments. I think skeptics correctly point out that the literature on transitional justice makes the case for the distinctiveness of transitions based on an overly simplistic or sanitized and idealized understanding of what ordinary justice in stable democracies looks like. I think the skeptics show convincingly that things are not nice and neat and clean in stable democratic contexts. And by providing an overly utopian view of stable democracies, the arguments serve as a useful corrective. So the question then lingers as to whether there is something distinctive about transitions and what the source of the distinctiveness is. And in the next section, I'm going to argue for a new account of what makes transitions distinctive, taking as my starting point the conception of stable democracies articulated by the skeptics, or implicit in skeptical accounts. So in an alternative account. In my view, to understand what makes transitional context distinctive, we should take as our starting point the idea of a normative shift in the conception of justice that organizes and structures a political community, which occurs during transitions. Now, skeptics note that transitional communities are not distinctive in experiencing a normative shift. So within a political order, shifts may occur as well. So if we're going to distinguish transitional contexts from ordinary contexts, it can't be on the basis of the occurrence of a normative shift. Rather, I think it has to be on the basis of the character of the normative shift that we find in transitions. And I argue below that the key to the distinctive character of the normative shift in transitions is the particular kind of uncertainty that accompanies a transition from an illiberal to a liberal political order that normally doesn't accompany a shift within a liberal political order. And I'll talk about two different kinds of uncertainty: existential uncertainty and uncertainty about authority. So part of the reason, I think, for the intense interest in transitional justice is that successful and lasting transitions to a liberal order are not the rule. Studies of civil war and civil conflict reveal an astonishing number of societies, 43%, returned to civil conflict within 5 years after negotiating a peace settlement. During the third wave of democratization, 85 authoritarian regimes collapsed. Only 30 of these regimes became stable democracies. An increasing percentage of societies constitute what political scientists are calling partial democracies, from 3.6% of 169 countries studied in 1976 to 26.1% in the year 2000. What I think these figures suggest is that in any given transitional context, there's enormous uncertainty about whether or not a normative shift will in fact occur. That is, in many transitional contexts, what the future holds is deeply uncertain. Perhaps there'll be a return to sustained conflict. Perhaps elections will be held, and if they're held, perhaps they'll be credible. Maybe the results will be respected by all parties to an election. Perhaps politicians will act ways that are significantly different from the past, or perhaps they'll use their new power to amend the Constitution to broaden the powers they enjoy. I call this particular kind of uncertainty existential uncertainty. I think the acute existential uncertainty that characteristically accompanies normative shifts and transitions is obscured by the implicitly teleological view that scholars like Teitel advance. So in Title's account, transitions are described in a teleological fashion, ordered linearly from an illiberal to a liberal political order. What's missing is an acknowledgement that the teleological projection is in most cases profoundly aspirational. The teleological picture of transitions depicted by Title reflects the deep hope that a given transition and its accompanying normative shift will be successful, but it doesn't actually capture the political trajectory it's reasonable to expect in any particular case. By contrast, within stable consolidated democracies, the same kind of existential uncertainty doesn't characteristically accompany a normative shift. Normative shifts don't typically pose a threat to the stability of the political order. There might be resistance to the enforcement of new rights or to shifts in policies, but there's characteristically no robust threat that the shift will undermine or destabilize a liberal political order. That is, consolidated democracies often can withstand such shifts. And I think this fact is reflected in the stability of full democratic orders in the short and long term, and I cite some studies to this effect. Now, this is not to suggest that shifts are always welcome. They're often not, and often vigorously and sometimes violently resisted. Nor does it suggest that normative shifts will occur immediately, or even that all potential normative shifts within stable democracies will actually occur. But rather what I'm suggesting is that it's often not a genuinely open question whether or not a normative shift that does take place will be enforced. Part of the reason why normative shifts in democracies are not accompanied by existential uncertainty, I think, stems from, very quickly, an absence of the second kind of uncertainty that I think we find in transitions, and that's uncertainty about authority. So that is, there's no stable framework of authority that delimits who has the standing to resolve the dilemmas and questions to which a normative shift gives rise, and what the principles regulating such authorities are. Specifically, within transitional communities, the issue of who gets to decide how past wrongdoing will be dealt with by the state and the criteria that should guide such decision makers is frequently contentious. I think the primary source of this kind of uncertainty about authority stems from the mixed character of transitional political orders. Transitional societies are, by definition, periods between authoritarian and democratic orders. Thus, their political order includes characteristics of both periods. During the transitional period, there's no immediate overhaul of authoritarian institutions and practices. Transitional societies have elements of liberal political orders coexisting with aspects of authoritarian legacies. And I think this coexistence complicates the question of authority. It implies multiple standards of authority may operate at the same time within a given community, some standards deriving from the authoritarian past or deriving from resistance to the authoritarian period, others deriving from standard democratic conceptions of norms for authority. At times, these standards may conflict. And importantly, I think the social, institutional, and moral conditions implicitly presupposed by democratic accounts of authority and often taken for granted in stable democratic contexts may be absent in transitional contexts, and their absence can be traced precisely to the authoritarian legacy or period of conflict. So the authority of many politicians in transitional contexts may stem from the role that they played in resisting oppression and repression during the authoritarian period, and little weight may be given in practice to the fact that such politicians were elected. Judges often occupy a complicated role during transitions, whereas in democratic contexts, the authority of the office of judges stems in part from their independence from political influence or interference or manipulation, and rather is based on being appointed in a certain kind of manner. In transitional contexts, the appointment of judges and the role in the transition itself is often deeply political. New judges are frequently appointed precisely on the basis of a political role they played prior to a transition, such as by serving as human rights lawyers, and the many judges who retain their position following a transition are often seen as compromised. There's also as an examination of challenges facing many judiciaries in sub-Saharan Africa highlights the profound implications that the weaknesses of judges during an authoritarian period and the lack of legitimacy of judges within a population have for the possibility of satisfying democratic criteria for authority. As legal scholar Kwasi Prempeh argues, During the transitions from authoritarian rule in the 1990s, a central concern became establishing the formal conditions for judicial independence found in stable democracies, including powers of judicial review and safeguards for political interference. The problem, he maintains, is that such guarantees are not sufficient to ensure that the judiciary will have the independence and authority based on this independence. For example, the legislative and executive branches often control the resources required for courts to function. And if judiciaries remain chronically underfunded, this creates an incentive for judges to do what's necessary to secure the requisite funding and makes them more vulnerable to political interference. The lack of legitimacy that courts have among populations can also undermine the capacity of courts to demonstrate their independence and strengthen the constitutional rights that are constitutionally guaranteed. If the public lacks awareness of rights guarantees and knowledge about or willingness to sue governments to see the enforcement of rights actually carried through. In a context in which competing standards for authority coexist, disputes can rise over who has the standing to decide how past wrongdoing will be addressed in what manner. By contrast, in the context of stable, consolidated democracies, the sources of uncertainty about authority don't obtain in the same way. Standards for authority derived from a democratic constitutional framework are well entrenched and without substantial challenge from competing sources of authority. And the social and institutional conditions required for such standards to be satisfied in practice, by and large, obtain. And I go on to talk more about that, but in the interest of time, let me just turn to the conclusion. So I've suggested that contrary to skeptical claims, there's two distinctive features of transitional contexts. Transitional contexts are characterized by two kinds of uncertainty not present in the same way as in stable democracies. The first is existential uncertainty about whether a transition will lead to democracy, and the second is uncertainty about authority that arises because of the ambiguous character of the political order of transitional communities that are often characterized by both democratic and authoritarian features, and because of the absence of many of the important conditions required for democratic standards of authority to be satisfied. I want to end by pointing out some of the resources this gives us for thinking about the question of what justice requires in terms of how we respond to the past. Consider first existential uncertainty. The presence of such uncertainty may exert an important influence in our understanding of how the legacy of wrongdoing should be dealt with and in what way. In ordinary contexts, responses to wrongdoing by the state do not have the deep ramifications for the stability of the political order they have in transitions. Thus, it seems appropriate, as scholars do, to concentrate primarily on the question of what is owed to an individual victim and perpetrator when articulating what justice demands. This focus can include, to some extent, a concern for the broader social dimensions of a wrong and the message such wrongdoing communicated. However, typically the societal dimension is relevant for cashing out why it's important for wrongdoing to be addressed by the state. By contrast, given the presence of existential uncertainty, it seems intuitively plausible that our understanding of what justice demands in transitional contexts needs to foreground not just the individual victim and perpetrator, but also the implications and ramifications of different responses for societies as a whole. In other words, it seems plausible to think that the fact that a transition is fragile should have some bearing on what a justified response to wrongdoing looks like, though it's not exactly clear what precisely this bearing ought to be. And I think the societal dimension doesn't arise in the same way in the context of stable democracies. And finally, the absence of a stable framework for authority in transitional contexts means that when transitional communities respond to wrongdoing, they do so in a context in which the kind of legitimacy that characterizes stable democracies is absent and trying to be established. Uncertainty about authority implies that there is no authoritative conceptions about who has the standing to address certain issues. And this raises the question, what can count as a source of authority in transitional contexts, and the standards for the legitimate exercise of authority in such contexts as well. In transitional contexts, the justice of responding to the past requires an articulation of who has the authority to do so and why. The standards or accounts offered for why the state and who within the state has the standing to respond, developed in the context of stable democracies, can't automatically be used for transitions, precisely because the democratic framework of authority is what doesn't obtain. Thank you.
Thank you very much, Colleen. Professor MacLachlan, yes.
Thanks very much. So there exists an increasing number of academic discussions focused on the political questions that arise specifically in transitions from authoritarianism and conflict to liberal democracy. In her presentation today, Professor Murphy has offered us new and compelling grounds for the conceptual claim that's presupposed in almost all of them, presupposed or just assumed. While she takes seriously, and this presupposition is namely that transitional justice represents a unique and a distinct kind of justice. While she takes seriously those skeptical claims leveled at standard explanations for the distinctiveness of justice in these contexts, ultimately, Professor Murphy argues, such distinctiveness arises not just from the normative shift in conceptions of justice, but from the distinct character of this shift. Specifically, she says these transitions are paradigmatically marked by both existential uncertainty and by uncertainty about authority. Indeed, recognizing and attending to the nature of both uncertainties directs us usefully towards those demands of justice that are specific to transitional contexts. In this way, Murphy's conceptual claim about the nature of transitional justice is also the beginning of a normative project, that is, defining the contours of what transitional justice, once appropriately understood, can and should demand from those in authority and from those in a position to recognize, respond, and obey. I want to begin my comments by noting that I am both largely convinced and also very excited by these conceptual starting points. I'm excited because, like Murphy, I'm interested in many of the conceptual and normative questions that surround radical political transition, and also the need to account for past wrongdoing. Now, these are typically not only complex from the perspective of justice, but they also invoke norms and values unfamiliar to so-called ordinary legal justice, at least as that's conservatively conceived. For example, talk of reconciliation and forgiveness, truth-telling and amnesty. Indeed, the presence of these values have led some to argue that transitional justice isn't justice at all, but euphemistically describes an uneasy compromise or compound, in which the demands of justice are not given their usual priority, but are weighed against other thick social priorities, priorities that are made just in name only. While she doesn't mention these specifically, the drive to define transitional justice as a unique and distinctive kind is motivated in part by the need to defend it and the measures associated with it, such as truth commissions, as something other than a corruption or a dilution of justice proper, while still asserting its status as something appropriately like justice as we typically understand it. Furthermore, Professor Murphy is right to notice that the explanations typically given, and I'd add when explanations are given at all, and that's fairly rare, do not fare well against skeptical concerns. Serious normative shifts in our conception of justice are not unique to a transitional context, and thus neither are the dilemmas and questions that arise as a result of these shifts, or the new concepts and standards needed to answer such dilemmas. Someone committed to a standard explanation, like that provided by Tito, could push for perhaps a quantitative distinction, arguing that while normative change is not unique to transitions, the sheer amount or level of change in a given time frame, maybe the number of norms in question, the degree of change each norm undergoes, and the resulting impact on political life, is sufficiently distinctive in the case of transitions. Democracies may change, they could say, but not that much and not that quickly. This alternative answer might work in the case of the first explanation, but would require more work to explain how normative shifts of a certain size suddenly create new challenges that require new conceptual standards. Furthermore, this kind of defensive answer would miss the deeper point that Murphy is correct to emphasize. The case for the distinctness of transitional justice shouldn't exaggerate the contrast between transitional and ordinary contexts by relying on an overly simplistic, sanitized, and idealized understanding of ordinary justice. Justice in transitions may not look like that, but neither does justice anywhere else. So I'm not going to focus on criticizing Murphy's new case for transitional justice, namely that transitions are typically or paradigmatically characterized by both existential uncertainty and uncertainty about authority. I think this is difficult to dispute and seems a good basis for defending the distinctness of these contexts. Similarly plausible are the effects of both uncertainties on how we conceive, understand, and implement the demands of justice. As Murphy concludes, deep and no doubt terrifying uncertainty about where exactly a given transition is going given the prevalence of regimes that cycle or bounce back between authoritarianism and democracy, is a reasonable justification for taking the fragility of a political order into account when responding to even grievous wrongdoing. Similarly, uncertainty over authority will require that we establish what can count as an appropriate source of authority, and this issue carries less weight when such things are worked out procedurally as part of what justice is. And we can go on, the same is true for standards. So Murphy's conclusion is tantalizing, and I personally would have liked to hear more about what we can learn about the unique demands of transitional justice and how far the insight from, if you like, the insight from uncertainty can take us in thinking about the specific demands of transitional justice by recognizing this grounding. But that's not the main point I want to press here. Instead, I'd like to finish by raising two questions about the implications of this conceptual case. First, I'd note that in making what I found myself calling the case from uncertainty, Murphy has actually shifted the grounds for the uniqueness of transitional justice, so the concept or norms of transitional justice, from the fact that it is, so to speak, justice in the context of transition, to the fact that it is justice under conditions of radical uncertainty. Indeed, a quirky consequence of Murphy's account is that I give an instance or a political example that somehow did reliably follow the teleological model that Rudy Teitelt proposes, for example, or what seemed to observers at the time to be likely to follow that model, wouldn't actually qualify as an appropriate context for transitional justice and the norms of transitional justice, since it would not really demonstrate sufficient existential uncertainty. So transitions that do go well and seem to be going well from the beginning may not qualify for having norms of transitional justice apply in this case. Or at least, that is, if both kinds of uncertainty are required to invoke transitional justice. I wasn't entirely clear whether they were jointly necessary, jointly sufficient, or simply typical or paradigmatic. And if the latter, then I think the question reemerges. Is transitional justice a distinct kind only in those cases that are typical, namely that show uncertainty? Or is it unique to all cases that belong to the type that is likely or paradigmatic to show uncertainty? And then does referring to type and paradigm instances of the type bring us back to those three other criteria that you want to say don't fare well against the skeptic? This isn't merely an idle question of language. The answer will make a difference to when and why we accept certain kinds of justifications as both authoritative and justifying. Insofar as the demands of transitional justice differ from those of ordinary justice, it matters which we decide have a right to be in play. So that's one question. But then at the same time, as I read Murphy's provocative paper, I found myself thinking about the implications of the case from uncertainty for non-transitional contexts, that is, normative shifts in our conception of justice in stable, consolidated democracies. Over the last decade or so, democracies too have begun to employ legal and extra-legal measures and procedures that are associated with transitional justice contexts in many people's minds. For example, truth commissions. The Truth and Reconciliation Commission, established as part of the 2006 residential schools settlement in Canada, is a recent and, as many of you will know, complicated local example. So what are we to make of vehicles of transitional justice outside of transitional contexts? And what does Murphy's project imply that we ought to make of them? For example, can these vehicles still help themselves to transitional justifications? In many cases, the processes and procedures that define these mechanisms express norms associated with transitional justice. Do they still have a right to these norms in non-transitional contexts without the two kinds of uncertainty to justify them? Must the norms be changed in some way? Must their justifications be changed? Or perhaps an alternative approach, I found myself wondering, might we take up the idea of existential uncertainty and place it in a new light? It's true that stable democracies rarely experience existential crises where it's not sure whether the law will be enforced at all or authority will be recognized or qualifies as a source of authority. But they do undergo what we might call existential crises of a very different sort. And I have to admit, I'm playing on an ambiguity in the word existential here. In the context of transitions, what's existentially uncertain is the very survival of the political community as such. In stable democracies, though, I think it's not the political survival of those communities, but their essence or identity, their very sense of themselves, their self-concept that can be at stake. But I think that the ambiguity might usefully illustrate a way of justifying so-called transitional measures outside of a transitional context, since in both cases the relevant justification may well appear to fragility. So it's not coincidental, I think, that the kinds of claims that lead to these measures, and particularly the need to address historical wrongdoing, are also those claims from justice that it seems least possible to address adequately, at least under standard conceptions of justice, within a given state's framework. Now, I have little to offer here, but I wonder if the normative implications of existential uncertainty, as Murphy describes it, might help explain some of the challenges faced by all democracies when it comes to retaining their self-concept in the face of wrongs of the past and the need to address them. Mm-hmm. In any case, Professor Murphy has certainly provided us with a stimulating and robust account of what is distinctive about justice in transitional contexts, one that takes seriously the claims of transitional justice and I find this very pleasing, the claims of transitional justice skeptics. And in doing so, she has raised some very interesting questions about justice in the face of deep uncertainty, both in transitions to democracy and elsewhere. Thank you.
Thanks.
Some brief comments.
So I'll just, so first I want to thank Professor MacLachlan for the wonderful comments that are really pushing me to think further about the implications of what I've talked about here. So to get at somewhat in the direction of an answer to some of your queries, I thought about how we would categorize different kinds of cases and when the demands of transitional justice apply. I thought I'd say something about the part of the motivation for the project that I'm working on and where this piece falls in the broader project and how that'll help address some of the comments that you have. So one of the things that made me interested in there are a number of things that made me interested in the idea of transitional justice. But one of the things that made me interested in trying to get clear on what precisely transitional justice demands and when the norms of transitional justice applies is the move to broaden the horizons of transitional justice that I see both in the literature and in institutions set up to designed to address transitional justice. So the International Center for Transitional Justice in New York tracks processes of transition around the world. And one of the processes that they've been concerned with looking at is the Truth and Reconciliation Commission in Greensboro, North Carolina. And when that was included, one thing that struck me was that the Truth Commission that's operating there seems to be operating under circumstances that are very, very different from the kinds of circumstances that other communities in transition are confronting and dealing with. And it left me dissatisfied, namely that the umbrella for transitional justice seems to be getting so broad that it renders the category meaningless, or it threatens to render the category meaningless. So one of the things that I'm trying to get clear on is precisely how we might, in a principled manner, decide when communities and which communities fall under this umbrella, and also when we can identify what about other kinds of cases have similarities, though aren't completely analogous to the standard or paradigm cases of transition. So in terms of, okay, so that's one thing to say. Now, whether I take the demands, both kinds of uncertainty to be necessary, jointly sufficient, or just typical, I have to think more about how exactly I want to frame them. They're not going to be jointly sufficient, though. I know that. And the reason why they're not going to be jointly sufficient is, at the beginning of my paper, I talked about two ideas, two routes into thinking about what makes transitional justice distinctive. One by looking at transitions themselves and what might be distinctive about them, and the second by looking at the legacy of wrongdoing and what might be distinctive about that. And I think a full, complete account of transitional justice needs to talk about both dimensions. So let me just say a few things about what I think might be differences in the legacy of wrongdoing. And this is preliminary, so you can tell me why I'm wrong. But some of the things that I think are going to be distinctive about the legacy of wrongdoing that's being dealt with in the context of transitions that'll also give resources for thinking about how the case in Canada that you were describing at the end might fit in its relationship to transitional justice. So I think that When we're thinking about wrongdoing in the context of transitions, typically one of the characteristics is that there's a diffusion of guilt, right? Guilt is very, very widespread. The categories of perpetrator and victim often overlap at the same individual or among individuals in very complicated ways, such that it makes it very hard to assess the blameworthiness of individuals in a very individualized manner. Another thing that's complicated is that what we might talk about is the courage problem. A lot of people aren't leaders or dissidents during a period of repression or during a period of conflict, but passively tolerate abuses that occur, join into committing abuses because they were coerced, or go along because that's the easier thing to do. And so doing the right thing prior to a transition when wrongdoing is widespread requires a lot more courage than doing the right thing we might think in stable democratic contexts. And so there's a question about what are the standards that it's appropriate to use to judge individuals' conduct when we're thinking about attributions of moral agency and blameworthiness. And often there's what we might think of as the opportunism problem. And a lot of these ideas were sparked in part by conversations with Kim Shepley at Princeton University. But you know, that people change sides when the political winds blow in different ways. And so that raised questions about how we ought to think about the actions or choices of individuals prior to and during a transition. So I think these three characteristics are going to be also important to sort of fleshing out what it is precisely justice demands when it comes to addressing a legacy of wrongdoing in transitional contexts. Right? We have to think about what is the nature of the transition itself and distinctive features about that, as well as about wrongdoing. And I think when it comes to thinking about addressing legacies of systematic wrongdoing in stable democracies of the kind that you were talking about in Canada, we can also talk about the same thing in the United States. It might be that focusing on the character of the wrongdoing that's trying to be addressed and the similarities it has to the character of wrongdoing in paradigmatic transitions will offer resources for thinking about why the norms or demands of justice are going to be somehow different than responding to what we might think of as ordinary crime in an ordinary context. One last thing to say, and then I look forward to hearing your comments. What I hope that thinking about the question of what makes transitions distinctive and wrongdoing distinctive, what work I hope it will do is provide resources when it comes to the thinking about justice and what justice requires. I take justice, well, one of the things I'm trying to think about is what is the core demand that a justice demand makes, right? When we think about distributive justice or corrective justice or retributive justice, what is it about those demands that are appropriate, make them appropriately fall under the umbrella of a justice kind of demand? One thing we might say is that it's about giving individuals what's due to them in some way or another. And so one of the things that thinking about questions of uncertainty and questions about the character of wrongdoing might offer is ways for thinking about how a certain kind of context or a certain character of wrongdoing alters or shapes what it is that's owed to individuals. That's very general and abstract and needs to be filled out in certain ways, but it opens up the possibility that for cases that don't fully meet all of the conditions that transitional justice cases meet, the dimensions that we do find in other kinds of contexts. If we can trace the ways in which those dimensions affect or alter or shape what is owed to individuals, we can then think about what that might mean in a different non-transitional, though in certain ways analogous kind of political context, what that might mean for what justice requires by ways of responding to wrongdoing. So it's a lot of, in a sense, promissory notes, but that's the kind of structure of the account that I want to develop, that I hope will offer resources both for categorizing moments as moments falling under the circumstances in which transitional justice applies, and also relating these moments to other kinds of moments that aren't identical but have similarities in certain morally salient respects.
Thank you very much, Colleen. This is really thought-provoking papers. I'm sure there'll be many questions, so I'd like to open to the floor if anybody has anything. Professor Berger.
Thank you so much. I enjoyed the paper, and we've had a chance to chat a little bit about it. And I just want to probe the first kind of existential uncertainty in the kind of mode of maybe continuing the skeptical, skeptical strain a bit. And in a way, it builds on one ambiguity in existential. But I want to go even further. And it's the question of whether or not there might be a bit of an undersale here to the extent to which the structure of the state and the notion of the state actually involves always existential uncertainty, not just of the character type, but of the true existence form. That states actually, quite stable states even, carry on in an uncertainty about whether they will continue to exist. So one way of getting at this is you have a little passage where you say 40% of partial democracies fail in 5 years, 7% of full democracies fail. And one way of reading that is say it's likelihood that drives the imaginary about the kind of steps we need to take to make justice look a certain form. But if you take the 7%, you say it's possible. We might not exist. We're a fully stable democracy. We might not exist in 7 years. And you actually see this kind of rhetoric, I think, pretty consistently. The United States, it's not hard to find. There are many places in which the language of a kind of maybe foolish, but nevertheless imaginary, quite potent, imaginary existential uncertainty is actually kind of part and parcel with the everyday deployment of justice and power. And so I just wonder if you might even be able to make a case that what you've put your hand on is actually something about ordinary justice, which is that it functions in a context of maybe greater or lesser, but actually existential uncertainty drives quite a bit of what the state is doing, even in very stable contexts.
Okay. So a couple things I want to say. So thanks very much for the question. I don't want to claim that there's no amount of existential uncertainty that we can find or that we could identify in stable democratic contexts. But I do want to claim that insofar as there is existential uncertainty, it's less widespread, and it operates in a different kind of way. So, both comments are drawing attention helpfully to kind of pressing me to clarify what exactly existentially is uncertain. Is it that a certain state will be there at a certain, or is it more about the character of the state that will be present, or the kind of order of the state that will be present? I think in some cases it can be the former, whether or not a given state will actually be around. But what I had in mind was actually the other kind of uncertainty, the uncertainty about what, insofar as a given state is going to be there, what exactly will it look like? What's on the horizon or for our possibilities? Are we, as a community, looking into a future in which what we find now is a brief respite of peace and an otherwise long-term trajectory of conflict? Are we looking at some promising noise that's being made about democratic reforms, but what we really face is an ongoing situation of much of the same in terms of the authoritarian character in which a community is going to be governed? And I think one thing that is different in transitional contexts is that that question is not just in the imagination, you might say. I mean, of course, how people think about their community is going to influence their actions. But I think in an objective sense, we might say, it's much more of an open question. And I think that shapes and influences actions of individuals in transitional contexts in ways that are different than the ways that existential angst or uncertainty among individuals in stable democratic contexts might. So if you genuinely don't know whether or not conflict is going to return or conflict is going to be around the corner, or you genuinely don't know whether or not democratic reforms are here to stay, that's going to alter or affect your actions in profound ways. It's going to lead you to be much more protective of yourself in certain respects so that you don't become a victim should conflict resume or repression return. And I think in democratic context, you know, so I'm in Texas, right? I'm not from Texas, but I'm in Texas, and Texans they imagine themselves as very independent folk, right? And there's talk about Texas seceding, right? Especially in the case of discontent with the current regime. That's not a real possibility. I mean, it's not like it's genuinely on the political horizon that Texas is going to become an independent community. It doesn't, that possibility doesn't inform, it informs the rhetoric in certain ways, right? It informs the discourse and the self-conception of Texans, but it doesn't alter the actions that individuals or members of the government have in any real profound or traceable manner. So I think that's a long-winded answer to your question, but and it's pushing me to try and articulate more what I mean. But I think that you know, it's not that it's wholly absent, but I think it's in stable democracies. But I think its presence is of a different kind of character, as well as a different degree in stable democracies. Yeah.
I think I'd like to jump in here.
Okay.
If
If
that's possible.
Yeah.
Colleen, I thought that was a really fascinating paper because I work on a topic that's, as I mentioned to you, that's related yet is not quite the same, and that topic is the topic of emergencies, right? So. The concept of emergency, and that probably goes to the nature of your endeavor, is an interesting concept. You could say, you know, suddenly I stained my white shirt, I need to go to the bathroom, that's an emergency. We don't really care about these emergencies. The emergencies that we tend to care about are situations where there's a risk of serious harm, and it's urgent that I do something to prevent that harm from materializing, or at least reducing it. And what really drives the concept, or at least its normative salience, is the nature of that harm, right? So emergency, at least in its significant sense, is a highly normative concept. And so when we think about national emergencies, the kind of national emergency that we think are legitimate, or in order that are basically declared or by states who want to preserve themselves because there's something good about them. When we look at Egypt or at Syria declaring states of emergencies, we don't think they should be doing this. We say that actually there is no emergency, or this is not an emergency that justifies the kind of response. Now I'm wondering what kind of concept transition is, whether it's the same kind of, or transitional justice, whether it's the same kind of normative concept. It seems to me that the way in which you describe it is not just the transition from X to Y, right? You want to say that is a transition conceptually, but it's not enough, right? You want to say it's a transition from an illiberal state to a liberal state, right? So again, what matters is the end, right? The liberal state, and then in emergencies, you could think of it in the same way. The liberal state that is basically the state that can provide justice, that forms a condition of justice. So my first reaction was to say, well, emergencies are departures from, say, the conditions of justice, whereas transition or move towards it. But in fact, it's the same problem, I come to think while listening to you, because emergencies are really you depart, but you want to go back to them, whereas transition is a move towards them, towards, as it were, the condition of justice. So that brings a number of questions to the fore, right? And you mentioned, well, okay, if that's the case, what authority in these situations of uncertainty is legitimate, can do or claim to bring about justice? I tend to be pretty instrumental about these questions. Well, the authority that is the best place to do so is, or can do it better than me, I should defer to that authority to do so. The second question that leads me to ask is, well, what is justice in your account, right? You speak of transitional justice, something that exists even if there is no state. Is it akin to morality? Is it a part of morality writ large? Or is it an end goal, right? We want to secure the conditions of justice so that justice can be done in a liberal Rawlsian sense, right? Because if it's the first sense, and I tend to think of there's a tension in your account that you want to refer to both, right? The question is, what can be done in order to achieve the conditions of justice, right? Can we depart from retributive justice as we understand it in the context of the criminal law and start detaining people so as to allow the state to secure the conditions that will then allow everybody to be safeguarded under its umbrella? And at the same time, well, is that just? Is that answer just? And so what sense of justice is at stake here? Is it both, and what role does it play in the account? I think there is space for both, but
Okay.
just want to put these ideas on
Wow,
the table.
that's great. So I don't know if I'm going to get at all the points that you were raising, but let me just say a few things. So the first is to say that one of the things that I'm interested in fleshing out is the relationship between emergencies and thinking about morality in the context of emergencies and transitional justice. There are certain things that I think are going to be similar and then important differences. So I think you've touched on one thing that seems to be common to both thinking about transitional justice and thinking about emergencies is the sense that there's something of value that wants to be, on the one hand, preserved, or on the other hand, developed.
Yeah.
And that valuable thing or state of affairs does some normative work in thinking about how we respond to different questions here and now. But I think one thing that's different between emergencies and transitional justice in part might be the nature of the question that's being addressed. So in transitional justice, the question that's at issue is how do we respond to wrongdoing that's been done in the past, right? That's what the question to which transitional justice gives rise. So it's about, what does justice require here and now of us as a community when we, insofar as the past wrongdoing makes demands and demands of justice on us, taking into account the context in which we're answering that question and the fact that the valuable state of affairs that, again, that also has normative weight, and I'm suggesting has to play some role in our answering that question. Whereas I take it in thinking about the question of emergency and morality in the context of emergencies, the issue of responding to past wrongdoing is not the central issue in the same way. It might be about what actions are permissible here and now in order to kind of be able to preserve or make possible a state that we value and want to see preserved. But I see the
Can I just ask a small clarificatory
Sure.
question? So it just dawns upon me now that there might be two things. There might be justice in transition and the process of the transition, and that is a very wide array of set of circumstances, right? So we could be at the beginning of the transition, in the sense like the conflict is just over. We might still be in it in some ways, or even parts of the conflicts could be part of the transition. And then the stage at the very end, right? We have achieved some sort of resolution. There is a stable set of institutions, and these institutions look at the past, right? And these questions might be different. In the case of emergencies, that can also be the case, right? So you cite in your paper, for example, the case of the Japanese Americans.
Right.
Right? So the case of the Japanese Americans that are interned during the Second World War because we think that they might not be very loyal to the American state, right? That's a case in which the Supreme Court looks at these situations ex post, right? Just like it would do in the case of a transition, right? As opposed to looking at it in the middle of things, right? So how would that be different? That would also be looking at the case of past wrongdoing in a sense.
Right. But what's different is that you're not asking that question of past wrongdoing in the context of trying to consolidate a transition to democracy. So when the U.S. Supreme Court asked, how do we respond to that past, they weren't asking that in a context where we're answering as we're at the same time trying to consolidate a transition to democracy. So I think, again, one of the things that I think is interesting about, not again, but thinking about transitional justice is that it has connections to a lot of other interesting moral dilemmas and concerns that come up. And one of the things I want to get clear on is precisely what the relationship among those questions and concerns is. And one last thing about what your comment brought to the fore. Another way in which thinking about transitional justice has expanded, it has been to make any kind of movement or decision a community makes in the context of transition to be about transitional justice. And one of the things that I want to I think that's a mistake. I don't think that every decision a community in transition makes necessarily is a decision that deals with or raises questions of transitional justice. So part of the value, I think, in getting clear on transitional justice is it allows us to identify when decisions are decisions or questions of transitional justice, and when they're decisions or questions of morality, but not necessarily, and perhaps of transitional justice.
Okay, so transitional justice could be a consideration.
Yeah,
Okay.
yeah, exactly.
Professor MacLachlan wanted to.
I
Oh,
just
yeah.
wanted to add a very friendly amendment before
Great.
we open it back
Great.
up again.
Yeah.
It occurs to me that all three of the things you've been pushed on so far all have to do, so you've laid out the criteria of existential uncertainty and then also uncertainty from authority. And then in response to my comments, added too that another important consideration will be the legacy of wrongdoing.
Right.
And these are all ways of getting at the distinctness of the kinds of demands of justice in transitional contexts in a non-circular way. So that doesn't beg the
Right.
question by saying it's because they're transitional.
Right.
And I think that's really good, but we've all been pushing you, trying to challenge the distinctness of
Yep.
1 and 3. And it occurs to me, so existential uncertainty and the
Yeah.
legacy of
Yeah.
wrongdoing.
Yeah.
Because it seems to me that both of those, in fact, are not going to be distinct to transitional contexts. Both of those in very important ways won't be. But I wonder whether fleshing out the kind of uncertainty about authority that you have in mind might help you set up a sort of non-circular way of getting at transitional justice as it applies to transitions and only transitions or mostly transitions. That might be the avenue that will be most useful in
That's
distinguishing
interesting.
transitions from
Yeah.
both kinds of existential uncertainty
Right,
and
right, right, right,
emergencies.
right.
Because it seems to me that the question about sources of authority are going to be slightly different there than they will be in all the other contexts. So I just want to suggest
Yeah,
that
that's
as a-
interesting.
as an avenue for
Yeah. I'm
getting
making
at
note
this.
of that.
Anyway,
Thanks.
sorry. back up.
Should I speak in the mic?
Yes. Oh, yeah, there are microphones around, and it's important that we speak in them for the camera. So.
I'm sort of tempted to think of issues like this in terms of Rawls's famous distinction between ideal and non-ideal theory. And my first thought is that that seems to go in a slightly different direction than
Okay.
what you're going in, right? Because what would make you think that you switch to non-ideal theory in a given case is the fact that if you pursue the ideal of justice, it's not going to work, right? Pursuing the ideal straight out or trying to live up to the ideal in the normal manner will sort of defeat the purpose. So for instance, I think a case in which something like what you call transitional justice seems particularly appropriate is a case in which half the population was involved in wrongdoing. And then you might think, well, the reason why we think that we need to switch our way of thinking about this is that, well, plausibly the aim of justice is to allow us to live together peacefully or something like that. And then if you send half the population in jail, then the aim of living together peacefully seems to be defeated. And it seems,
Right.
there's also the problem of diffusion of guilt, where are these people really, really that guilty and so on. And so you think, well, we need a different way of thinking about things. We need a way of starting over and so on. But it seems to be because just trying to live up to ideal theory straight out would be counterproductive or something like that. It would be a perversion of justice, or however you want to put it. I'm not sure how much it has to do with uncertainty. It may have to do just with the scale of what happened and the extent to which, being too much of a formalist about how we're going to answer what happened is going to screw everything up. So I'm curious to know what you think about that.
So thanks very much. I think, so let me just say one thing about why I'm resistant to using that strategy. One way people think about transitional justice questions is in terms of justifying what are morally second-best strategies, right? So morally speaking, we prefer that individuals, when they've done something wrong, be punished. We can't, for a variety of reasons, pragmatic and moral, do that. I pointed to some moral considerations that people point to the fact that, well, judicial institutions, even of the best kind, just can't handle a kind of onslaught of, thousands and thousands of cases all at once, and the state of the judiciary, often in transitions, even if it were possible to handle the volume of cases, just isn't equipped to do so. And I think that going that direction leads to the conclusion that we're not really dealing with or responding to wrongdoing in a way that's just. We're doing it in a way that's morally justified, all things considered. taking into account the various constraints that we have, taking into account the importance of trying to achieve certain ideals. But it's something in the way that we respond to wrongdoing that ultimately is to be regretted. And were things different, we would hope things were different so that we could respond in a different manner. And I think what the ideal of transitional justice is, at least by those who advocate it, what is trying to be suggested is that it's a mistake to think of responses in transitions that aren't of the same kind as responses in ordinary contexts as somehow second best, or as necessary because the conditions that would allow us to kind of directly do what justice requires or directly act in a way that we achieve the ideal, using your terminology, aren't on offer in this set of circumstances or in the context of transition. And so I'm trying to explore and take seriously the idea that there may be ways of responding to wrongdoing that are different than the ways that wrongdoing are dealt with in the context of stable democracies, that aren't just a matter of finding morally second-best strategies, that aren't just a matter of doing what we are forced to and understand why is justified given circumstances, but wish things were different such that that's not the way we had to go. So that's kind of one thing and the other thing is I think I have a hard time with the ideal non-ideal distinction in general. So in my book on reconciliation, I was trying to develop an account of political reconciliation that didn't fall into the non-ideal ideal category, or kind of division of labor. And I think so one thing that I'm uncomfortable or find troubling about the non-ideal ideal distinction is that it's not entirely clear to me what value or resources thinking about conceptions of justice under highly circumscribed or idealized circumstances should tell us for thinking about justice or relationships in the less ideal, very messy world in which we find ourselves. And so, so another way, my answer of why not approach things from a Rawlsian perspective is I don't find, for me, it helpful to think through questions about what justice requires or what political reconciliation involves, thinking first about the ideal and then turning to the messy world and trying to think about what that means or what resources it offers me when confronted with that. I'd rather start with a very messy world and then in the context of that try and think through what morality and justice requires given that.
Could the messy world be just a situation of warfare? Couldn't that be the place to start with, where it's ripe with moral dilemmas? What would be a possibly just response from an individual standpoint in that kind of context, and then moving up from there, as opposed to, because it's hard for me to know where you're starting. You say post-revolution, okay.
Right.
Does that mean there's a state? If the state is there, we already have a new element that tends to weigh a lot in our thinking. We tend to think, well, the state ought to be what delivers justice, right? There might be arguments to be made for and against, but I'm just thinking if we start from the time of the conflict moving, there might be a duty to move out of the conflict, bring the civil condition up. There might be a duty to, it's all based on self-interest, let's try to, like, I'm just wondering whether that might not be the right starting point.
So I started thinking about, so I think for thinking about reconciliation, the appropriate starting point is thinking about the context of war. Because I think that, or repression, so the account of reconciliation of the process of rebuilding relationships, I argue, takes the material to be theorized is precisely the character of political interaction among citizens and officials during conflict and repression, and conceptualizing what are the problems, morally speaking, in the paradigmatic interaction that we find, out of which we can construct a conception of what repaired or rebuilt relationships look like. For thinking about transitional justice, though, I'm not convinced that starting with war, or the context of war, is going to be appropriate in the same way. So I agree that there's going to be difficulty, especially in practice, but also in theory, in precisely articulating transitional or distinguishing transitional from non-transitional contexts, either at the beginning, right, the emergence from conflict, or at the end. But I think One thing, there's different moral questions that come up from the perspective of justice when we're thinking about the context squarely of war versus the context of transition. When we're thinking about the context of war, we're thinking about the norms of just war theory, for example, as they apply to conduct there. And the question of how we respond to wrongdoing that's conducted in the course of war doesn't come up in the same way. The morality of our thinking is about kind of evaluating actions as we find it there. But I think if we start there, we miss the... I'm not being very articulate, so here's a very inarticulate way of getting at what I think is missing. I think we miss the aspiration that fundamentally shapes moments of transition. And it's an aspiration that kind of defines what it is that's going on, right? We're no longer in a period of conflict. That's not to say conflict can return. Peace agreements have been signed. Peace might not be very might not be very stable, but we're not dealing with the ongoing situation of war. And the question is, what do we do about what just happened, given that we don't want to go back to where we just came from, and yet we're not plausibly in a position to be where it is we want to go?
Okay, we have 3 questions. Short.
Yeah, sure.
I wonder would that could be encapsulated in the idea that there needs to be a just cause to a war for it to be justified. If that idea of the just cause could not encapsulate these ideas of bringing about the conditions of justice in the same way.
Yeah. No, that's yeah.
So Mohammed, Craig, and then.
Do I need a mic or?
Yes, that would be great. Maybe we can just pass this one. Yes. Just the mic.
Yeah, thank you for that wonderful paper.
Yeah.
I had an opportunity to read it right before coming. So I'm going to try something here different, and maybe I'm completely off. If I am, feel free to tell me so. I feel like the 2 criteria you identify, the existential uncertainty and the uncertainty about authority, seems to be playing a dual role.
Okay.
The one role they're playing is that they're identifying what makes transitional justice distinct. So you don't want to put it under this umbrella term, or if you can't put it under the umbrella term of justice, you want to make sure that it has a special status. But it also seems to be at least playing another role where it's part of the criteria for identifying when a state is going through some transitional period. So there's an existential uncertainty to a sufficient degree, and also there's a lack of authority or identifying an authority. Now, if that's the case, and if it's at least 2 of the criteria, and there may be many more for being able to identify when the state is going through a period of transitional justice, I worry that there may be some kind of descriptive inadequacy in being able to capture some of the instances that we want to say are going through transitional justice. So the example I have in mind is Egypt, which I imagine is on the minds of many. I'm not sure if the uncertainty of authority exists in that example. The Supreme Army seems to still be pretty much in control. I mean, obviously, Hosni Mubarak has been removed, and a few of the high officials have been brought to Egyptian justice, whatever that amounts to for the time being. But I feel like there's an instance where we want to say there's a transitional justice going on in that state, but the criteria that you give seems to, at least normatively speaking, not wanting to do that as an example of a transitional justice state. So that's just my general.
We have a quick follow-up.
Sure.
Professor
Sure.
I think it probably makes sense for me to just, this is exactly much more articulately put than I would put it, but what I was going to ask about, that part of the phenomenon that you mentioned when you gave the Greensboro example is truth commissions or truth and reconciliation commissions, tend to be 2 different names for them, tend to be emerging in contexts sometimes that one doesn't expect, but that includes potentially this kind of situation, which raises the fundamental issues. Is there actually a transition of the right kind for anything like this kind of institution to be the thing that we need now? So I'm working in 2 contexts in which the question comes up. One is Honduras and one is Sri Lanka. And with respect to Honduras, there are two sort of independent, notionally competing commissions. One is called the Truth and Reconciliation Commission, set up officially. This is all post-coup. It was a coup in 2009. Their benchline point of reference is that the moment there was an election afterwards, about 6 months later, and the current president took office 2 months after, so that's 8 months after the coup, that the transition started, and that the period that has to be looked back upon is only those 8 months. The Civil Society Commission, the Truth Commission, doesn't actually believe we're out of a conflict. They actually see it all as one continuing pattern, and they have a different narrative of why, including they have a much different focus on human rights and the state and paramilitary role that hasn't changed much, and on some dimension has gotten worse. And yet, the civil society community, at some level, is happy enough to have recourse to a truth commission, a civil society one, mind you, that would be part of their response. Now, whether their hand was tipped because the state, the official actors, the diplomatic community pushed the state to create an official one, or whether it was conceptually consistent with them to say, we're still going to have a truth commission, even though we're in the middle of a conflict. And when you go down there, that's the discourse. There's no transition. This is still a conflict. Sri Lanka, it's not quite as clear, because again, it depends on what your baseline is. If your baseline is the end of a ferocious civil war, well, yes. In the kind of pure armed conflict, yes, no sense, there is no more armed conflict. But an underlying conflict of a very real sort has not ended, and what's maybe even more important is there's a deep continuity in the underlying repressive state structure, and it's getting worse actually since the end of the war, given the way the government in Colombo is consolidating itself. So at one level, your point is well taken that we need some conceptual clarity over when the institutions paradigmatically associated with transitional justice should appear, but the fact is they are appearing in these other contexts, and I'm wondering if it has any of these other kinds of just case studies can help think about the transitional justice case, because both of these cases, I would say, at least have elements of we're not even in a transition.
Right, right.
And yet a bunch of other people think we are treating it as if we are. So.
Yeah, so these are both really helpful comments. And so the first thing to say is that I need to think more about the question of demarcation, right? The question of demarcating transitions from non-transitional contexts. And then also about the relationship between institutions set up, how we should think about the relationship of institutions set up in different kinds of contexts, or where there's competing understandings of what context a community is in. Let me just say one thing about the descriptive adequacy, or the end goal. So one thing that a lot of the comments are making me clear of is that I need to get clear on the moment of transition at the front end, right, from conflict to the transitional period, from repression, and what the markers there would be, which is precisely what the example that you were getting at. And I don't have, and I just need to think more about that. So that's the first thing to be said.
Oh, the key data moment, that itself will always be contested.
Yes, yes, that's true. Now at the other end, when you're no longer in transition, there are some things I want to say that I think will address the question you have about Egypt and what my account would say about Egypt there. So I've been pressing or articulating these two dimensions of uncertainty as distinctive for the sake of getting clear on ultimately what that might mean when it comes to thinking about justice. But I don't take them to be sufficient for demarcating what it is when it is a community's in transition and when it's no longer in transition. So there, moving away from transition or saying a community is no longer in transition is going to have to draw on key criteria that mark the presence of a consolidated democracy. And there, I noted at the beginning of the paper that there's disagreement about that, whether it's institutional criteria, whether it's more practice-based criteria. I myself think that the best way of answering that question is in terms of looking at the characteristics of political relationships, which will have both institutional dimensions, but also some conventional dimensions, or require us to look at social norms and attitudes of citizens and officials as well. So a fully marked, full set of criteria for identifying when a community is no longer in transition at that end, and also in the, is going to look not just for the presence of uncertainty, but also for other kinds of things, and also at the front end. In terms of the uncertainty about authority, again, there, in one sense, it's a descriptive question about whether or not people are unclear about who's in charge, but it also has a normative dimension. So, because communities in transition, in the context that I'm interested, are transitioning to democracy, they're transitioning during a period where democratic norms of authority are supposed to be taking root, right? And are in the process of taking root in ways that'll displace and change the standards for authority that were there before. And so it's precisely because things aren't the way they were before. So it's not just that the Army's ruling, or even that the Army will have the same place in a stable democratic context, but that role that needs to change, that leads to uncertainty, right? Because now it looks like, you know, the power, the authority they have is not contested, is the same. We don't want it to always be like this. And so what does that mean for how we think about the actions that the Army does now? And how do we think about what that means in terms of authorizing, ultimately, those we want, or the institutions we want, ultimately, to be established and consolidated moving forward? So, so the idea of existential authority raises questions about what are the criteria for consolidated democracy. It's not that they're wholly separate criteria, but it is. So I just wanted to draw attention that it is descriptive. Of course, who people think, uncertainty about authority is often a matter of the fact, the function of the fact that people don't know who's in charge, right? But there's this other dimension too, in that it's uncertain how we should think about who has authority, or who even should be in charge in the context in which things are changing. Yeah.
Lost the food here. I just have a question, just wanting to get a little bit clearer about the project.
Okay.
So I can certainly see that there are a bunch of good questions to ask here. How do we deal justly with past wrongdoing? How do we deal justly with the fact that we're in transition, if we are?
Right.
How do we deal with uncertainties of the various kinds that you talk about?
Right.
I can certainly see that those questions often come up at the same time, in the same spot, maybe not always. So there's a kind of overlap of questions there, and so we're going to want some story to tell about the cases where there are no overlaps. But I take it, or anyway, that's part of the question, that you also think that these are somehow questions, interestingly, of the same kind, and you're going to call for answers, I suppose, of, to some extent anyway, the same sort. And I'm just wondering, it's too big a question in a way, but just what exactly makes them questions of the same kind, and what makes them call for answers of the same sort? Is there a...
Right. So I want to say, again, this would be a struggle for articulateness. Okay. Take the questions that you were laying out. How do we deal justly with wrongdoing? How do we deal with the question of uncertainty? How do we deal with, it was the fact of transition, right? The three that you were asking. Okay. One approach you might have is to say that these questions are distinct questions, right? They contingently, as a matter of fact, they come up at this particular moment. But when we think about them in a way, we can think about them in isolation, right? So we can think about how justly do we deal with wrongdoing. I'll focus on that one. And that question is a question communities face not just in transitions, but also in the context of stable democracies. So skeptics of transitional justice want to push that point, right? And say fundamentally what transitional justice is asking is about what justice requires when it comes to responding to the past. And we can answer that without having to appeal to anything distinctive about transitions, right? So why am I resisting that, thinking of that question in isolation, and why do I want to bring in the other one? Part of it is because I'm not satisfied with the implications that thinking of the question, what does justice require when it comes for communities dealing with wrongdoing, the implications that has for how we evaluate the responses that communities in transition, the responses that they have, and even how we think about the choices that they make, or that with which they're confronted. Because thinking about the question, what does justice require when it comes to wrongdoing, in isolation from thinking about questions of context, I think frames our thinking in the way that transitional communities are bound to fail in satisfying the demands of justice, and are bound to fail for reasons that might lead us to excuse what they've done, the responses that they've had, appeal to certain mitigating circumstances, but sort of, in a sense, stacks the deck against transitional communities in ways that I think, that's one thing. And I think another thing is it obscures what I take are important moral dimensions of that question of responding to wrongdoing, and moral dimensions of the choices communities have, precisely because those dimensions aren't always present when communities are asking the question, how do we deal with wrongdoing? So part of the motivation for trying to link the questions together, for thinking about justice, the justice involved in wrongdoing, while taking seriously the question of context, is to try and get at an account that takes seriously and has at the forefront the kind of character of the choices transitional communities are actually trying to make, without necessarily stacking the deck in such a way that here's the gold standard and you're just going to fail. And we might excuse for various reasons what you do, but you can't really respond justly to the past in these conditions. I'm at least open to the idea that there are responses of justice of which we can make sense. So that's kind of the motivational background, the reason for linking them together. Now, I started this project with the idea, completely open to the idea, that that my conclusion will be at the end of my research, there is no such distinctive kind of justice that's distinctive, namely transitional justice. As I've been working, I've become more convinced that there's something here, and I just got to try and spend more time trying to articulate what it is. But the beginning of the project was, at least let's make the best case we can, and that'll be instructive too for thinking about why, after all, what we're dealing with is ordinary questions of justice. Because I think one thing that bothers me about the skeptics, as much as I'm bothered by arguments for transitional justice, is that I don't think in many ways they take seriously the character of transitions, right? Because it's easy to say, well, we find the same thing here, right? We deal with this in the US all the time, or in Canada all the time. And you want to say, well, sort of. Right, it's not entirely different, but really, you want to say we're dealing with the same kind of thing? So, my answer is more by way of an autobiographical explanation of how I got here, as well as the kind of intuitions that are driving me to say that I think, frankly, thinking about ordinary justice implicitly presupposes a certain kind of context. And that's not explicitly articulated. What is the context and how that's what work that's doing in the answers that are given to questions of what justice demands. And I think one thing that's useful about thinking transitions is looking the other way, we can get clear on how, without recognizing it, context is doing a whole lot of justificatory work in our answer in the other case.
That's helpful. That just occurs to me.
Sure.
Is it almost by definition the case that if you're dealing with questions of transitional justice, you're dealing with questions of past wrongdoing as well, just because since you're transiting from one conception of justice to another, in some sense everybody was indeed.
Yeah.
So we tend to focus on the kind of South Africa model where there's wrongdoing.
Yeah. Yeah.
But in a kind of way, you couldn't escape it, I suppose.
Right, and the way it's because of how the transitional. So part of I'm taking the literature. I'm trying to articulate the concept that we find, and it is precisely about past wrongdoing. The other thing I was going to say at the beginning was there are lots of questions about transitions moral questions that come up. Not all of which will be transitional justice questions, precisely because they won't always be about the past, and so there's other questions to be asked.
Isn't it the same thing for criminal law? It looks at past wrongdoing and also has some forward-looking dimensions in terms of deterrence. We don't want this to happen again.
Right. So the justification of punishment. Certain kinds of justifications of punishment are forward-looking in precisely this way. The justifications for punishment that kind of are the starting point for concerns about the ways wrongdoing are responded to in the past are more retributive in nature. So the real reason that people, a real conviction that people have that they think responses to wrongdoing and transitions don't satisfy is that when you do wrong, justice requires that you suffer for its own sake, that there's something about the demands of the past past wrongdoing that makes demands on us now, that we take seriously what happened, not just for the sake of, not just because we want to prevent people from doing bad things in the future, but that. So it's
but if you're retributivist, it's the same for criminal law, or if you but even these mixed theories.
Yeah. So you might. So it's interesting, kind of how an account of transitional justice will relate to mixed theories of punishment in the domestic criminal context. So I'll have to think more about that. But the conviction that skeptics of transitional justice, the moral conviction and the justice conviction that they think isn't being satisfied, which is why we're dealing with morally second best strategies, is the retributive conviction that, look, if you, especially given the character of the wrongdoing done, right? If any case is going to kind of make us retributivists, it's the cases we're dealing with, and
which is why authority becomes so interesting.
Yeah, exactly.
That second point
yeah.
We have some follow-ups there.
No. Okay. There's going to be one quick point, but maybe a second. The first is this is maybe so starkly obvious as to be stupid to say, but it may be that in fashioning an approach that ultimately is responding to skeptics or critiques that are saying this can all be accommodated within a more general discourse of justice, is nothing so different. There might be a tendency to want to create a degree of solidity or conceptual clarity about a category known as transitional justice, when in fact what might be needed is a lot more subcategories. At minimum, transitional justice 1, 2, 3, 4, 5 maybe. And then the question becomes, if you mix those two terms, just to get semantic about this, transitions of the following sort and justice questions of the following sort. Now, if you hold constant and if it's being accepted from the beginning that we're only talking frankly, then that most transitional justice discourses are almost only about a degree of sort of either criminal justice, to some extent criminal compensatory justice of some form or another, but broader notions of justice don't tend to come into the picture. You don't hear transitional justice as the label for talking about distributive justice issues that come out of repressive eras. It's just not the language used, but it's necessarily the case. It isn't. So maybe justice can be held more constant than the rest of it. And could it ironically be the case that the more particular you get within the transitional justice category, the more you're going to be able to draw on and convince the skeptics, because you're going to be particularizing in a way that people are going to be able to recognize a lot more in terms of general principles or general contexts. And so it will be particularized, but the discourse between you and the skeptics is going to be a lot more nuanced, because they can't work with the category of transitional justice. It's just too broad on its own right, but they could work with the much more particularized, the context where X, Y, and Z happens, I can see how this relates to these general principles. So it's just that's one thought. And the other was going to be that the assumptions that the justice label is perhaps held too constant in most transitional justice discussions. And it makes it a lot easier. But is it really looking back at wrongdoing in this kind of mostly criminal law sense that should capture our attention? Is it just because that's really what it's been all about, and so the field is defining the concept? Not really sure, but I've never been all that satisfied about that, including as I've been thinking about this in Honduras and Sri Lanka. You start getting into notions like, is truth-telling its own form of justice? And if that's the case, in some respect, is one so limited by the kinds of wrongdoing or the kinds of community harms that one is going to be dealing with in that truth-telling exercise? The more one starts saying, but we need justice, that the we need justice part almost always means we need prosecutions and convictions. Right? So...
Yeah, no, that's really interesting, and I think, so just a couple of comments. I think what will happen as I'm moving forward, as I get a picture of the kind of features, and especially when there are multiple features that characterize or mark out transitions, certain paradigms of transitions as distinctive, you will end up with transition 1, 2, 3, which will have a family resemblance of a certain kind, but certain features will be present and certain features won't. And I think I hope it will make discourse more fruitful in terms of thinking about why things might be different, morally speaking. One of the big questions that I need to address is why we're not dealing with transitional morality, you might say, rather than specifically with transitional justice. And so to answer that, I think the first thing I need to do is get clear on, and I said something to this effect earlier, what it is that makes it the case that we're dealing with or responding in a way that's just, as opposed to responding in a way that's moral but not. And that question is surprisingly hard. And frustrating too, because the way that discourses about justice are framed, it's so specific about, articulating or developing a specific account of distributive justice or retributive justice or corrective justice without theories, despite Rawls's title, of justice, or accounts of. So I think, so that's one thing I want to answer is, or at least address. I don't know if and have some account of an answer of when we're in the justice ball game, you might say, or the arena of justice. And I think that will be helpful for answering things like, is it so important that it be a response of justice, right? Or that we respond with justice? Or is it, at the end of the day, more important that we respond morally? And why that in transitions, and why that's so, and so again, this is a lot of, sadly, because it's the beginning of exciting for me, but dissatisfying for my answers. It's a lot of promissory notes, but it's precisely the things that I want to get clearer about because of the questions that come up where, you know, there's real answers that need to be given and explanations to people that, and justifications that need to be offered for why we are dealing with justice insofar as we are, because I think a lot of the restorative justice literature is too glib with justice talk. And so, you know, let's take seriously, when are we talking about justice, when aren't we? And maybe it's okay if we're not talking about justice always, but let's get clear about why that's so, if it is so.
It's very interesting. In the literature on emergency is the same problem. When I started working on emergencies, people said, well, Francois, emergencies are like events that happen on Friday, right? It could be anything, right? You could have family, but is there really the puzzle of emergency? It's really hard to see. You can say what an emergency is conceptually, but in terms of theorizing responses, it's much more challenging because you have all sorts of situations like that. So I really like this comment by Professor Scott. Any last question? Yes.
I'm not sure I'm going to articulate this well. I read your piece on political reconciliation and international criminal trials, and the involvement of the international community in international justice contexts, and the idea of the source of the normative shift in these contexts, and whether it comes from the international community exerting pressure on that society or culture, or whether it comes from within organically, whether fighting stops because the international community has stepped in, or whether the oh, I didn't have a microphone, sorry. I just realized that. I'm not sure if it matters, but thanks. But essentially, whether, in your opinion, the source of the shift matters, and does that affect the legitimacy of the process, whether it came from organically from within, or whether it was exerted upon that society from without by the international community?
That's really interesting. So here's my intuitive reply. So I'm going to have to think of how precisely it's going to be. So my intuitive response, or my not worked out, initial response is, yes, it's going to make a difference. One way I think it's going to make a difference is in answering the question that uncertainty about authority gives rise to, right? So if there is uncertainty about who has the standing to respond to wrongdoing, and why, and in what way, that gives rise to the question of how one acquires authority, right, to respond. And I think answering that question is going to have both a procedural, you might say, component as well as a more substantive component. I think it'll be important in answering or responding to what justice requires in resolving uncertainty, in establishing authority. That's going to have certain procedural implications, as well as having a certain kind of conception of what we want the norms of authority that we're trying to consolidating to look like after a certain process has been achieved. And there, so the work that I did on reconciliation, a central component was respect for agency, right? Respect for the agency of the actors whose relationships are in the process of being repaired, and how that constrains and shapes international actors responding in certain contexts. I think that same concern is going to play out, morally speaking, in thinking about questions of transitional justice, but I don't have worked out precisely how that'll go. And one thing that I also want to get clear on is the place of reconciliation in thinking about questions of transitional justice. And I think that'll also have implications for thinking about the question that you were asking. So thanks for that, because yeah, another thing I'm going to have to think more about.
Okay, thank you.
I'd ask you to please join me in thanking Professor Murphy for a wonderful paper.
No, thank you all. This was very, very helpful.